Welcome everyone, and thank you for joining us for today's webinar titled Understanding Pre-Removal Risk Assessments, PRRAs. My name is Bahar Taheri, and I'm the project consultant with the BC Refugee Hub, and I'll be guiding us through today's session. I'm joining you from the unceded traditional territory of the Coquitlam First Nations, which lies within the shared territories of the Tsleil-Waututh, Katzie, Musqueam, Kakite, Squamish, and Stolo nations. It's important for me to acknowledge the lands that I'm privileged to live, work, and raise my children on as a way of showing respect and honoring the Indigenous peoples of these lands. Acknowledgement for me is a simple way of resisting the erasure of Indigenous histories and working towards honoring and inviting the truth. ISSBC's BC Refugee Hub would like to gratefully acknowledge the funding for this project from the province of British Columbia through the Ministry of Post-Secondary Education and Future Skills. I will provide just a short intro to the BC Refugee Hub. The BC Refugee Hub was established in 2015 by ISSBC and the province of British Columbia, originally in response to the arrival of Syrian refugee families. Today, our focus is on refugee claimants through the BC Safe Haven funding through the province of British Columbia. We offer a wide range of tools, fact sheets, and training sessions like this one to support the sector and promote services across British Columbia. We have our BC Safe Haven service directory, and the service directory is updated on a quarterly basis. It includes program details, referral contacts. We've actually just updated it, and the newest one will come out this week. We keep this updated to promote referrals between organizations for BC Safe Haven programming. We also connect with our partners and through meetings that are generally hosted by AMSA, and we also have a monthly e-newsletter, and we post events and services on the BC Refugee Hub as well. So I believe Kieran Davis usually joins us to provide a short introduction to the BC Safe Haven Resource Network.
Thank you, Bahar. I'd like to offer a brief land acknowledgement. As a provincial umbrella association, AMSA acknowledges that BC is on the unceded homelands of First Nations who have stewarded this land since time immemorial. We recognize the privilege that we have as settlers on this land and acknowledge that AMSA's operations are on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations. As an organization, AMSA is committed to creating a safe space for Indigenous voices. The BC Safe Haven Resource Network is a collaborative program providing key supports to refugee claimant serving organizations in BC. The resource network is collaboration and partnership focused. It includes multiple partner organizations who play a key role creating resources for direct service providers. The BC Safe Haven Resource Network has 4 initiatives. The capacity building activities include webinars, fact sheets, and many other resources, as well as supporting organizations to develop humanitarian movement plans. Our mental health activities include in-person workshops, e-learnings, and information sessions, and a phone line for frontline service providers to get support as they work with vulnerable clients. Our language activities include the development of the BC Safe Haven curriculum guidelines, which provide guidance and information for those working with refugee claimants in language classrooms. And finally, our public support gathering is engaged through ACE's AMSA's charitable arm in partnership with United Way BC to build community support for refugee claimants, including public awareness, donations, volunteerism, and other community-based supports. I encourage you to connect with AMSA on LinkedIn, Facebook, and X, formerly Twitter, and visit our website at www.amsa.org for many resources, e-learnings, and recent reports. Thanks, and back to you, Bahar.
Thank you, Kieran. Great. So now that I've introduced everybody, I'd now like to introduce our speaker for today, Katie Lay, who is a lawyer with the Immigration and Refugee Legal Clinic, will be joining us today to present on this topic as our topic expert. As I mentioned earlier, we will have a Q&A session with Katie afterwards, and I will turn it over to you, Katie.
Thank you so much. Thank you all for joining. All of you who have joined from BC, who have joined from other provinces. It's really, really wonderful to have you all here. I am a staff lawyer at the Immigration and Refugee Legal Clinic, which is a free legal clinic for vulnerable people in British Columbia. And we see a lot of people who would ideally be making refugee claims, but who will now need to be making pre-removal risk assessment applications. And that is the lens that I'm coming into this presentation from. So hopefully this will be a very thorough overview for all of you. That said, if you do have clients who might need any specific legal advice, you are welcome to send them to the Immigration and Refugee Legal Clinic, and I'll have our information at the end. To start, I would like to acknowledge that I am currently located in Vancouver, which is the traditional territory of the Musqueam, Squamish, and Tsleil-Waututh nations. In my work, I have a lot of clients who have been forcibly displaced from their homelands, and I think it's very important to remember that the land that we are welcoming our clients to is also land from which people have been forcibly displaced. It is an ongoing cycle. It's not something that's new. It's something that has been part of this messed up world for eons. And I think in this work specifically, making those connections and keeping that in mind is very, very important to ground us to where we are. Today's agenda, we will start with a general overview. I'll explain a little bit about Bill C-12 and pre-removal risk assessments, which I will be referring to as PRRAs. I will talk a bit about eligibility for PRRA, what the application process looks like, and then what happens after you've filed your application. So a pre-removal risk assessment, or PRRA, is used by the Canadian government, specifically CBSA, to meet Canada's international obligations against refoulement, which is Canada's obligation not to send people to a country where they would be at risk of death, harm, cruel and unusual punishment. It's part of the basis of Canada's refugee system. When someone is facing removal, Canada or the CBSA will offer a pre-removal risk assessment to people who are eligible. And this is a way of assessing the risk that someone would face in their country of citizenship. Ultimately, the question that the assessing officers will look at is whether you are a person in need of protection, a person in need of Canada's protection. If you are someone who has worked with a lot of refugee clients, you might be familiar with persons in need of protection, protected persons. Essentially, a person in need of protection is someone who needs to stay in Canada because they cannot return to their home country due to a risk of torture, a risk to their life, or a risk of cruel and unusual treatment or punishment. This is covered by Section 97 of the Immigration and Refugee Protection Act. Persons in need of protection have also, or do also fall under the refugee category. And as I will get into later, there are quite a few similarities between PRRA and refugee claims, but this is kind of the main focus of the PRRA. The very, very general legal test is that you must be personally subject to danger of torture, and there must be a personal risk to life or cruel and unusual punishment. So this is something that is specific to you. It's not a general risk. This is the cartel is knocking on your door. It's something that needs to be forward facing. It's something that needs to have a real risk. You cannot have state protection as an option. You need to show that there is nowhere else in the country that you could possibly live that would be safe. And the fear needs to be ongoing. Bill C-12, why are we in this mess? Bill C-12 was passed in March, I believe, earlier this year, and it has rendered thousands, tens of thousands of people ineligible to make refugee claims. It has rendered people who have already filed refugee claims ineligible. And the reason for this is that anyone who has entered Canada after June 2020 waited more than 12 months since their first entry to file a claim and filed their claim on or after, I believe it's June 3rd, 2025, is now ineligible to make a refugee claim. This is quite a complicated explanation or quite a complicated set of people to conceptualize. So I find the easiest way to make this make sense is by using an example. If you entered Canada in December 2020 on vacation, left, and then came back in December 2025 to file a refugee claim, you would be ineligible because you first entered after June 26, 2020, and have waited more than 12 months since that very first entry to file your refugee claim. You weren't in Canada during that time, but the 12 months starts from that very first entry after June 2020. It's very, very difficult because a lot of people, I would say most people, have rendered themselves ineligible without even knowing that that was a possibility. It is not super common for people to, I mean, it's common, but not everyone files immediately. Some people don't realize it's an option. Some people are in Canada and then things get very dangerous in their country of citizenship. It is very, very restrictive and does not look at the realities of being a refugee. And so for all of these people who have been rendered ineligible, PRRA is the solution. Ineligible claimants who have already filed their refugee claims will receive either a procedural fairness letter asking them to clarify the dates that they entered the country, or will receive a letter notifying them that they are ineligible and will be offered PRRA. Usually not in that letter. Usually in the letter, they'll be informed that at some point in the future, if they're eligible, they will be offered PRRA. Ineligible claimants who have not submitted refugee claims will sometimes submit a refugee claim to trigger being offered PRRA, because, as I will explain shortly, PRRA is something that you cannot just choose to apply for. Getting into some of the differences between PRRAs and refugee claims, just to highlight why this is an insufficient substitute for a refugee claim. So a PRRA must be offered by a CBSA officer. You cannot choose to just apply for PRRA. Whereas with a refugee claim, you can apply within Canada when you choose to. It's before 12 months. You can apply at the border when you enter Canada. You have more control over that application. It's on your terms. With a PRRA, there's no automatic right to a hearing. Refugee claim, you do get an automatic right to a hearing. PRRAs are not bound by the IRB guidelines or the national documentation packages, which are information packages that are compiled by the Immigration and Refugee Board and are referred to during refugee hearings. Refugee claims decision makers are bound by the guidelines and the national documentation packages. PRRA has no appeal, only judicial review. Refugee claims you may have the right to appeal and then judicial review after. And with a PRRA, your removal is only stayed if you apply or submit your forms within 15 days of your PRRA being offered, whereas with a refugee claim, there is an automatic stay of removals. I think it's also important to note that PRRAs are decided by IRCC officers who they say will now have specialized training, but they are IRCC officers, whereas refugee claims are decided by specialized Refugee Protection Division decision makers. So there is a difference in the level of specialization and training and expertise there as well. Eligibility for a PRRA. As I said, a PRRA must be offered by a CBSA officer. It's not something that you can preemptively apply for. In order to be eligible for PRRA or to be offered PRRA, you need to be what they call removal ready. So you need to have a removal order and it needs to be valid and able to be carried out. This isn't necessarily as easy as it sounds like it should be, because there are a lot of people who cannot be removal ready. There are a number of countries that have either an administrative deferral of removal or a temporary suspension of removal against them, which means that Canada, for policy reasons, for safety reasons, is not carrying out removals to these certain countries. And those countries include Sudan, Afghanistan, Iran, Lebanon, Democratic Republic of the Congo. There's a number of countries. I believe Syria is on the list. And so if you are from one of these moratorium countries, one of these countries with an administrative deferral of removal or temporary suspension of removal, you will not be removal ready because you cannot be removed from Canada. And that means that you end up in a very difficult limbo position of not being able to make a refugee claim, not being able to make a PRRA, not being able to go back home or back to your country of citizenship. In those situations, you are eligible for a work permit. The work permit needs to be extended every year. It's a very, very difficult position to be in, and is something that I don't believe the government really thought of when they were coming up with this new bill. Other people who are not eligible for PRRA are people whose claims are ineligible under the Safe Third Country Agreement, people who are found to be a convention refugee in another country. As I said, if you're from a moratorium country, if you are subject to being extradited, or if you have made a refugee claim that was refused and it's been less than 12 months since your last negative decision. So if you filed a refugee claim, it was refused at the RPD 12 months ago, you should be offered PRRA. If you appeal it, that sets a new 12-month deadline. If you go to the federal court, that sets a new 12-month deadline. Prior to Bill C-12 passing, this was kind of the most common barrier to PRRA that we saw. Now, I would say the most common barrier to PRRA that I see is Bill C-12 ineligibility. I've made a note here that there are some exemptions to the 12-month bar. One of those is if you have a dependent child, and another is if there are serious medical considerations. What is the PRRA application process? So you are PRRA eligible, And you wonder what happens. If you are called in for removal, they begin removal proceedings. Usually that involves being called in for a meeting with CBSA. You will be offered a pre-removal risk assessment by a CBSA officer. Typically, this has happened in person. Now it seems like they're doing them online. I imagine because of the volume of PRRAs that they are offering. And it is very, very important to accept the offer. Even if you're not sure if you want to do it, accept the offer, because if you reject it, there's no going back. And they literally, like on the offer, on the page, they will give you two little tick marks. You accept or you reject, and then you sign. So I always, always, always tell my clients, just accept it. It doesn't hurt. If you accept and you have done that in person, the forms will just be given to you. If it's done online, they'll usually be mailed to you. And the PRRA typically involves that application form, submissions, and evidence for why you would face risk in your country of citizenship. PRRA applications are totally paper-based. That is, I would say, one of the biggest, probably, yeah, the biggest difference between a PRRA and a refugee claim, and one of the things that makes PRRAs particularly difficult. You will need to provide all evidence and all your arguments in writing. You have 15 days from the day that you are offered your PRRA to submit your forms. And then you get an additional 15 days to submit your evidence. So from the date you're offered PRRA, that's 15 days to submit forms. And then from the day you're offered PRRA, 30 days to submit evidence. I've made a little note here that if the forms are mailed to you, you get 22 days. Still not much time. It is very, very important to keep in mind that this is your chance to provide everything. So you need to give written submissions outlining the risks that you would face if you're removed. You need to explain why you can't move to a different part of the country, why this risk is specific to you. All of those factors that I went over when discussing persons in need of protection, this is where you would address all those factors and explain why that applies to you. It is crucial to make sure that the submissions and evidence are clear. My usual approach is explain it to the officer like they're five. Just explain everything thoroughly, cover all your bases, don't make assumptions, don't assume the officer will understand what you're saying. This is your one chance to address all the reasons why you need to stay in Canada. And because you likely will not get a hearing, it is very, very helpful to include sworn testimony, because a sworn statement, like an affidavit or a statutory declaration, holds the same weight as testimony in a hearing, and will be given significant weight usually. It's also important to refer to the national documentation packages and the IRB guidelines, which I mentioned in my little comparison chart, because they won't necessarily be, or they will not be automatically considered. So you will need to bring them up yourself. And then it's also important to refer not just to past persecution, but future persecution too. The forms tend to focus primarily on past persecution, but forward-facing risk is also very, very important. Hearing. As I mentioned, PRRA applicants do not have an automatic right to a hearing. You need to request a hearing, and you need to explain why you need a hearing. There's no recording of the hearing that's made. there's no transcript that's provided, and counsel is not allowed to make submissions. The hearing is limited to exactly what you request in your initial request. It's focused just on those points. And the hearing usually doesn't help that much, to be honest. It can be helpful, but usually they don't hold much sway. They are not as determinative as a refugee hearing. Usually they're not really determinative at all. So even in the best case scenario where you do get a hearing, it's not going to make that much of a difference usually. I mentioned this section of the Act. So the factors that will be considered and that you'll need to address in any requests are whether there's evidence that raises a credibility issue, whether the evidence is central to the decision, and whether the evidence would justify allowing the application. So basically, you need to show that if there's any kind of potential credibility issues, that the evidence in support of your client could be so crucial that it would justify allowing the application. It's narrow, and it is difficult to get a hearing. That's one of the huge issues, and one of the big issues that lawyers have been kind of rallying to litigate is the lack of a right to a hearing, especially for people who have been pushed down this route instead of being eligible for a refugee hearing. For the people where this is their one chance, this is their equivalent to a refugee hearing, this is their equivalent to a refugee claim. So hoping that this is not the be-all end-all, hoping that there is some movement, but as of right now, this is kind of the best case scenario for hearing. What happens next? You have submitted your PRRA. If you submit your forms within 15 days of being offered your PRRA, you will get an automatic pause or stay of your removal. And this is crucial because if you do not submit your forms within this timeline, they can go ahead with removal. And that obviously is not ideal. You will also be eligible to apply for an open work permit if you apply within 15 days and for health coverage under the Interim Federal Health Program. The work permit can take a while to process, but even having that as a possibility, it can be very, very helpful. And you can access, other services like health coverage, which for some clients is life-changing. PRRAs can take a very long time to process. They can take a year or longer. They can take a really short time to process. It is a bit unpredictable. And I think with all of these changes to the process and all of the adaptations that IRCC is making, it might stay a little unpredictable just because they are trying to adjust and then we're trying to adjust to what they are doing. If you submit your PRRA forms late, not only do you not benefit from the automatic stay of removal, but you also do not benefit from being able to apply for an open work permit or health coverage. So that 15 days is crucial. And again, that's 22 if your forms were mailed to you, but absolutely crucial. If your PRRA is approved, you become a protected person. If you are inadmissible to Canada for serious criminality, then you don't become a protected person, but you are given a stay of removal. So you don't get the protected person status, but you are not removed to your country of citizenship. This isn't a super common situation, so I won't get too into the details. I'll say if this happens, you can contact us. You can contact IRLC. If you are found to be a protected person, you will not be permitted to return to your country of citizenship. This is similar to how it is for successful refugee claimants. If you return to your country of citizenship, or if you use the passport from your country of citizenship, you may be found to have re-availed yourself of the protection of your country, that is, to have accepted the protection of your country of citizenship, in which case Canada might say, great, it's safe again, and remove your status. One of the important benefits of becoming a protected person is that you can apply for permanent residence as a protected person. And this is the same process as with successful refugee claimants. It's the same type of application. You don't have to apply for permanent residence. Some people do choose to just stay on work permits, but obviously if that is the goal for people, then this is really, really helpful. If your PRRA is refused, there isn't an appeal process. You would instead go to judicial review through the federal court. And that's where you would explain why you think the decision is either unreasonable or procedurally unfair. There are very kind of specific definitions of those terms, legal definitions, which I won't get into in much detail here. Again, if this happens to a client, you can send them to, this happens to a client and they're in British Columbia, you can reach out to the Immigration and Refugee Legal Clinic. There's no automatic pause on removal while the judicial review is in process. It's not automatic, so you would need to request a stay of removal, which is where the federal court will pause the removal. And this may or may not be granted. If it's granted, then that's fantastic. But if not, then they can proceed with the removal while the judicial review is in process. If your judicial review is not successful, or if you're unable to file a judicial review, or if, there's any other barriers, if your stay is unsuccessful, you will likely be removed from Canada. There are some important considerations when working with clients who may be PRRA eligible, who may be on the path towards doing a PRRA. Most of them have to do with the very, very short timelines. 15 days is not a lot of time. 30 days is not a lot of time. If you have a client who would be a refugee claimant, but for Bill C-12 ineligibility and wants to go the PRRA route, things that are very important to do, ideally beforehand, are translate any documents that are not in English or French to English or French. The officers will not consider any documents that are not in English or French. So that is crucial, especially since this is entirely paper-based. The same goes with collecting evidence. The more evidence you can collect ahead of time, the better. It's not something that you have to start when you're offered PRRA. You can collect evidence. And for many people, a lot of the evidence that you would use in a PRRA are very similar to the is very similar to the evidence that you would use in a refugee claim. So people may have evidence already, news articles, letters of support, that kind of thing. Interpretation can be really, really important for filling out the forms for clients. And if it is possible to have someone like ready to help fill out forms, that would be fantastic. I know it might not always be possible, but that will not be provided. So that's something that the client needs to kind of find for themselves. And a lot of clients are offered PRRA and not explained what is going on. So that is also something where that is also a place where you might be very, very helpful in explaining what the heck this means, what the timelines are, what the purpose is, because often people that I speak to have just been given this form, told to accept or not, and have not been explained anything. These are also becoming, of course, increasingly common. Historically, they've not been the most common type of application. So a lot of people just aren't familiar with them. Another thing that can be very, very helpful, specifically in British Columbia, I'm not familiar with legal aid in other provinces, but legal aid can provide coverage for PRRAs in certain circumstances, and they are open to providing contracts preemptively. So if you have a client who will be offered PRRA or who is PRRA eligible, you can approach legal aid and see if they will be able to provide coverage for a client, which is incredibly helpful because before it was only if you'd been offered PRRA, and with the short timelines, it was just not super feasible to actually get legal assistance. So that is, I think, a very, very important consideration. Legal aid is accessible by phone. You can go in person, and they are available for people who are facing an immigration proceeding where they might be removed from Canada. So PRRAs, refugee claims, that kind of thing. There are financial ceilings on who is able to access legal aid. It's mostly to ensure that legal aid goes to people who cannot afford a private lawyer. And legal aid will ask for financial documents to kind of confirm your financial eligibility.
So thank you all for joining today on this very important topic and all the work that you're doing with refugees and refugee claimants. And thank you for joining from not only in BC, but across Canada. And we would again like to thank the province of British Columbia for their support and funding for this training activity today. And then Katie, thank you again for joining us for a second time and
Yeah.
providing information, answering all the questions that we had today. It's invaluable to have a lawyer with us to discuss topics like this. And
Yeah.
yeah, thank you. And then if you want to join our e-newsletter, you can just use the QR code or go to the bcrefugeehub.ca, and it's at the bottom of the page. So thank you, everyone.
Thank you so much for having me.
Bye. Thank
Bye.